My name is Heather Haven, and I'm the Associate Dean of Research and Graduate Studies here at the College of Law, the University of Saskatchewan. And I'm very pleased to be able to welcome you here today to the talk, The Law Can Be Hazardous to Your Client's Health and Yours Too. This is a lecture that is being delivered by Professor Emeritus John Lande and presented as part of our McKercher LLP Lecture Series here at the College of Law. And as we gather here today at the college, we acknowledge that we are on Treaty 6 territory and the homeland of the Métis people. We pay our respects to the First Nations and Métis ancestors of this place and affirm our relationship with one another. I would like to begin by thanking McKercher LLP for sponsoring this lecture series for the last 4 years. This sponsorship allows the College of Law to present on a wide range of informative, educational, and entertaining speakers at our law school that have that are of interest to both law students and our greater legal community. Now I'd like to introduce our speaker, John Lande. John Lande is the Isidor Loeb Professor Emeritus at the University of Missouri School of Law and the former director of its LLM program in dispute resolution. John has received numerous awards for his work. He earned his JD from Hastings College of Law and a PhD in sociology from the University of Wisconsin-Madison. He began practicing law and mediation in California in 1980 and directed a child protection mediation clinic in the 1990s. The American Bar Association has published a recent book of his called Lawyering with Planned Early Negotiation: How You Can Get Good Results for Clients and Make Money. And he's near and dear to my heart because John and Professor Michaela Keat and myself are also publishing a book with the American Bar Association that will be out in January. Did you see the plug I made for our book? That's coming out in January, called Litigation Interest and Risk Assessment: Helping Your Clients Make Good Litigation Decisions. So without further ado, I want to call John forward. And John has indicated that he's happy to take questions. So we'll have some time at the end of the lecture for some questions, but I guess if there's something burning that you just can't wait, you could. He said he's used to being a professor and being interrupted, so I guess that's okay. But I will leave time at the end for questions from the floor. Please join me in welcoming John Lande.
Thanks very much, Heather. I just turned on the mic. Is there anyone who cannot hear me well? Okay, I'm going to infer that means that you all can hear me well. I can see folks in the back are like students in my class in the United States who would much rather sit in the back than in these wonderful seats in the front row. But there are more seats in the front row for those of you who are so inclined. I really appreciate the invitation to be Saskatooning today. I've been working with Professor Keat and Associate Dean Heaven on a book for more than a year, as she mentioned. In the United States, in my law school, the norm is to go by professor this, professor that. And I'm happy to go by first names. If you like, I would tell my students that they could call me John, Mr. Lande, Dr. Lande, Professor Lande, or Oh Great One, Master of the Universe, whichever one they're most comfortable with, and I offer that to you as well. I'm going to refer from time to time to Heather and Michaela. I'm not sure if that violates your norms, and if so, tough luck. The book that Heather mentioned is Litigation Interest and Risk Assessment: Help Your Clients Make Good Litigation Decisions, out in January of 2020. They tell us it will be fabulous. I've had a lot of people read it, and they said every law student and lawyer should read it, so I'm sure that you all will. And today's talk is based on that book and some research of mine. We're going to talk today about the benefits and risks of conflict and litigation, identify risks to litigants, identify risks to lawyers, identify risks of law school to students, which I'm guessing is a lot of you all, and suggest ways to manage these risks. And one of the things that's really important is to hear your experiences. It's really boring if I do all the talking, so I'm really looking forward to having a conversation with you as we go along. So, caveat. Some of my presentation is based on my work in the U.S. I know that really this is essentially the U.S. North, but there may be some differences. But that'd be nice, you know. I thought Canadians were nice. Okay. The situation may be different in Canada, and we can talk about similarities and differences. So, Stone Soup process. Stone Soup is a project that I organized, and basically the idea in a variety of ways, and some of you actually have had this inflicted on you already, is to have a process of having students experience the real world of practice and to incorporate learning from in a variety of ways, one of which is in presentations like this. So what will happen is that we are going to, we have a note taker, Kyla's daughter Lauren is over here. It's Lauren, right? Okay. And I'm going to elicit feedback from you, and she's taking notes, and I'm going to write a blog post, and she's going to take notes without names, and I suspect that that will be easy because I'm guessing you probably don't know most of these students or members of the audience. And then I'm going to post it on the Indisputably blog where I write a lot, including this PowerPoint. I know that you're all, well, those of you who are students are all diligent students, and you're going to be tempted to take copious notes on everything that's in the PowerPoint, but the PowerPoint itself, as well as notes that Lauren is going to make, will be on the blog, so you don't have to feel obliged to take notes as we're going along. It will be on and the blog is just indisputably.org. So the PowerPoint will be there, and if you don't want your statements to be included, one, you probably don't need to speak up, or you can talk to Lauren afterwards and say, please take that out. So any questions about this process? Going once, going twice. All right, so about me, as Heather mentioned, I graduated from law school in 1980. I practiced law and mediation in the San Francisco Bay Area, got a PhD in sociology, taught at the University of Missouri since 2000. I'm retired, but I'm still active, regularly blog. Okay, so now you know everything you need to know about me, as my sister would say. By show of hands, how many of you are first-year students here? Oh, a bunch, good. So we haven't indoctrinated you fully yet. This is just the beginning. How many of you are upper-class students? Oh, look at that. This is really impressive. You don't have to be here, and still you're coming. I guess it's the pizza. How many of you are law school instructors? Oh, look at that. You don't have to be here and you're still coming. How many of you represent clients? Do you have any practitioners? Oh, look at that. You don't have to be here and you're still coming. How many of you mediate cases? Okay, a couple of mediators. That's good. All right, so I'm not sure. Anyone who I've left out so far? What do you do? Oh, I'm sorry. Oh, great. Wow. Okay. Anyone else? Lauren was going to say go ahead, Lauren. Do you want to say who you are? Just a fourth-year international student. Okay. So now we know who you all are. So conflict and litigation. So by show of hands, have any of you been involved ever in a conflict? Show of hands. Any of you been involved in a conflict? Looks like a bunch of you have, but there are some of you who either haven't or are liars. So what was good about being in the conflict? I'm a professor, I can wait. I can call on people too. All right, there's a fellow in the back. Okay. That's good. You can learn from conflict to avoid in the future. Someone else had a hand up back there. Okay, what else?
You got a good story out of it, and you feel good about yourself for your cause if you win.
There you go. A good story is a really good thing. I mean, it may not be fun in the moment, but boy, are those some amazing stories about the conflict. Go ahead.
Get your perspective heard.
Yes.
Learn both sides of the issue.
There you go.
Helps it challenge and define how you feel about the conflict.
Yes, one of the things is you can learn about that, which is implied in what a lot of you are saying. So, I mean, the reason I'm asking this question is there's sort of an assumption, I think, for a lot of people, particularly those in the dispute resolution world, that conflict is bad. And so I want to start off with the premise that that ain't necessarily so. But sometimes conflict is not so much fun. So think about some of the conflicts you've been involved in. What were troublesome aspects of the conflict? Yeah, like it hurts. Yeah, and it's just scary and what else? I mean, that you got that, Lauren? Go ahead in the back there. Yes, well, especially you Canadians. Although I realize that I'm using horrible stereotypes, and just please forgive me. So, yeah, I mean, one of the problems is precisely that. If you're going to try and be reasonable and cooperative and the other side is not going to, that feels really bad. Other things that are not so good? Paperwork. Oh, this is from the oil rigger. Yeah, so paperwork. It's a lot of hassle. Most people don't really like being in conflict. Now, a similar question, but have any of you or someone you know been a party in litigation? Okay, so a number of you have. So, although, actually, can I see those hands again? So, actually, I would guess that's maybe a quarter of the audience. And a bunch of those are practitioners. So, so what was good about being a party in litigation? And how is that different from being someone who's in conflict?
Felt like the issue was being addressed.
Okay, so again, it was a forum. So much, and it's being addressed. Someone pointed out that in terms of conflict, you have a chance to kind of air things out. One of the things that happens in litigation, it's being addressed in a formal body, in a formal proceeding, where if you have a conflict with your romantic partner or a relative, typically you're probably not going to be in court, but you will have a chance to have it aired out. Here you're having it aired out, and you're having a chance to express your concerns in a public forum. What else is good about litigation? There you go. If you're a lawyer, you make money. And related to that, there are a bunch of law students here. This is going to provide you, hopefully, a source of income in the future. What else is good about litigation? Nothing. Why are you even in law school, you know? What are you, crazy? Okay. One of the things is that people tend to be in litigation because they can't resolve things on their own, and so going to court may help you get the outcome you're looking for from someone on the other side who's being unreasonable from your perspective. Any other virtues?
It takes a really long time, so the other side might settle.
There you go. You can wear down the other side. We have a cynical practitioner here, I can tell. What else? Good argument will be at a good lawyer. So one of the things is that hopefully you'll have a good, just resolution. And of course, sometimes if you have a bad lawyer, well, let's not talk about that. So what's, why is this not working all of a sudden? Oh, because I'm maybe pushing the wrong thing? Oh, now we're really messed up. Oh. Oh, there we go. But it also has, press the wrong one. There we go. All right. So I'm going to say some things why it's really important. One is it resolves disputes directly, as we've talked about. it provides a structure for promoting settlement. One of the things that happens is that if you didn't have a litigation system, then a lot of people wouldn't settle. It's only the threat of going to court that prompts some people to get real and to settle. And it creates BATNAs. And some of you know what BATNAs are already, and if you don't, I'll tell you, it's the best alternative to a negotiated agreement. So what happens is if you think that you go to court and your best alternative to going to court is you're going to get a certain result, then that frames the way you think about what you'll do in negotiation. So if you think that you're going to get $100,000 in court, then you're, as a plaintiff, you'll think, well, I'm not going to, if I can get maybe $90,000 in settlement, then that's pretty good because I'd only get $100,000 in court maybe. And so you think about it that way. I'm shocked, actually, that you all didn't talk about promoting justice, although I guess, the upper class people I'm not so surprised about, but the first years, isn't that kind of what you would expect, that this is what this project is about, is to promote justice? I'm being facetious, but of course it is a really important role of litigation. It deters potential lawbreakers because they fear that if they break the law that they will be held to account and have to pay for it. It holds individuals and entities accountable, provides legal remedies, and again, I'm sort of shocked. What kind of students how do you teach these students? I mean, you provide legal doctrine. This is what you learn here, at least in the United States, and I gather, I'm told here in Canada as well, that you all learn from appellate case reports, and so this is how the common law develops, is from litigation. It also has some risks. You could lose in court. There's a lot of uncertainty. You incur tangible costs. It's darn expensive. Of course, that's bad news for the clients, maybe good news for you all when you're practicing. Being facetious again, it costs a lot in terms of fees and expenses. One of the things we're going to talk about a lot is intangible costs, which people often don't pay a lot of attention to, and it's really something that is a lot of what our book is about and what you all as practitioners should be thinking about. It can cause a lot of stress. It's extremely stressful for the parties. It causes a lot of delay, which may provide some benefit in making the other side give in. On the other hand, if you are the other side, the delay it may force you to give in, or the delay is really nerve-wracking. It can hurt your reputation. There are opportunity costs for doing things, for distracting you from doing things that you might not otherwise do if you weren't involved in litigation. So as I say, I'm going to talk a lot about intangible costs, which are often ignored or given short shrift, especially in appellate opinions. I remember when I went to law school a very long time ago, back in the dark ages, and I'd be reading these appellate case reports, and I just was so struck. The parties were like non-entities. They were like ghosts. They were barely mentioned. It seemed to be so focused around the judges and their point of view, and sometimes you had the lawyers who sometimes were referred to, seemed to be characterized as schnooks. Do you know what schnooks is? It's jerks. The judges would say, gosh, I can't believe that the lawyers would make this stupid error, of law. And the parties, when parties have a dispute and they're in litigation, I don't think very many of them are thinking about what the law is. They're thinking, gosh, I know what I want. I know what I think I'm entitled to. I know what the other side is doing and that they're wrong. But they're not trying to vindicate the law, which is really what the appellate courts are about. And the appellate opinions really don't talk about this intangible stuff, which is really what parties care about a lot. And one of the intangible costs is litigation stress. And one of the things that I learned in the process of writing the book with Heather and Michaela, very depressing to look at the clinical research about how, just reading it made me sick. I mean, it was just so discouraging. It can interfere with parties' mental, emotional, and physical lives. I mean, seriously, produce flashbacks, nightmares, physical symptoms. It can degrade people's cognitive functioning and increase cognitive biases. Cognitive biases are things that we all have. It's why we make poor judgments for lots of different reasons, one of which is that we have a self-serving bias. We think we're doing the right stuff and the other person, they're wrong. And so and there are a lot of them in general, and litigation exacerbates these cognitive biases. It focuses parties on the past, prevents them from moving forward. Almost always in litigation, it's about some event that happened in the past, and people are living and reliving the past. And of course, the remedies that the courts provide, at least in the United States, and I would bet here in Canada as well, very rarely are focused on the future. It's more about adjudicating what happened and what the legal remedies ought to be for what happened in the past. And sometimes for parties, that's really important. For most people, moving ahead in their lives is really important, and they want to move on, which is one reason why a lot of people don't litigate at all, or if they do, they want to settle as soon as they can. And if they are having physical or emotional treatment for either things related to the litigation or not related to litigation, it can really disrupt their treatment. I mean, being in litigation as a party is bad news in general. I mean, it has some of the benefits that we talked about before, but in general, I'd rather be in, Philadelphia. There are almost lots of other things I'd rather do than being a party in litigation. So it can damage relationships, make parties obsess over the matter. Parties sometimes will shut down and disengage because they're so focused on what's going on in the litigation. Can interfere with the lawyer-client relationships. Clients can get paranoid. One of the things for those of you who are law students, and this is another thing that I think isn't conveyed very well in the appellate case reports that you're reading, is that it makes it seem as if the lawyers and the clients are very much on the same wavelength, and what the lawyers are presenting in court is exactly the way the parties are thinking about it, and that they're like this. The reality, which I am sure that the practicing attorneys will support me on, is that that is not the way it always is in practice. That there's a lot of conflict actually between the lawyers and the clients in practice about the way things are going. Clients often are suspicious of their lawyers, and the litigation process can exacerbate that because lawyers have a sense they've been around the track a number of times, and they will they become cynical, and they sort of say, well, I know this is what you want, but that's not what the legal system can provide for you. So just be a good boy or girl and play along with me and do this litigation thing, and that's not the way most parties feel. And so it's something you need to be paying attention to throughout your law school career, and I would say in your career in practice as well. It increases client sensitivity to lawyers' communications, can create suspicion if lawyers are on their side, and of course the other lawyer. There is no person who is more deserving to go to hell than the lawyer on the other side. It's not good, and can cause decision fatigue. So basically you're asking clients to be making lots of decisions, and if they're stressed, it can be really hard. And this research we've been focusing particularly that we describe is really about individual parties, and of course all of those things can happen for individuals who are employees in organizations who are litigants. And you might think, well, you're an executive, you're an employee, this won't bother you. Well, wrong. This stuff can churn and eat at them as well. It can also create problems for the organization as an organization. So it can cause board members, executives, employees to fear for their future, depending on how the litigation plays out. They may have to be deposed. You may use a different word here, but basically have to testify under oath, and that may cause some problems, and of course the outcome may not be good for them. It can damage employee morale, can harm, literally it can harm employees' health, their productivity and decision making. It can lead employees to focus on their personal interests rather than the organization's interests, can cause internal conflict, can create groupthink bunker mentality. So if it's us against them, I remember talking with a lawyer who was the high-up lawyer in a major multinational corporation, and this is true in lots of big corporations. They're just people. It's not like they're these people on high who are rational thinkers who have their heads on straight. They have the same problems that affect individuals as individual litigants can harm them, and there are pressures for them to reinforce each other, this kind of groupthink. It can divert time and energy away from organizations' goals, increase opportunity costs, impede innovation, damage companies' brands and reputations, and then require repair of their brand and reputation. So that's for the parties. So, I mean, in some ways, it's like, why would you be a litigant? And we've talked about why you'd be a litigant. There are some advantages, but there are a lot of downsides. And one of the things that is important for lawyers to do, and then we also have some mediators who do this as well, is to help parties think through what the consequences of going through the litigation are and help them, which is not necessarily to dissuade them, although that may be something that you will do and lots of lawyers do. There's a famous quote of a lawyer who said, half a job of a lawyer is to tell a client that they're being a damn fool and that they should stop. And so a lot of times lawyers will have clients come in or prospective clients come in who are very upset, and the lawyers will say, I know you're upset, I know the other side did you wrong, but this isn't a wise course of action for you to go into litigation. So it's got lots of problems for the parties. But it's also not good for lawyers. Research has shown that lawyers have more mental health and substance abuse problems than people in the general population. One researcher found that, I couldn't believe this, but that's what she found, that 70% of lawyers in a study were more likely to develop alcohol problems over their lifetime. I mean, in some ways that's funny, but it's not funny at all. I mean, not only is that bad for the individual lawyers, but it causes, ripple effects to their families, to their clients, to their coworkers. I mean, this is serious stuff. And some of the causes. So why do you think, why do you think lawyers have these problems? I mean, we're training you to do this. No one's holding a gun to your head to go to law school and be a lawyer. So why do lawyers have all these problems?
Lack of emotional intelligence. Law schools primarily focus on IQ, not developing emotional aptitudes and communication skills.
Yeah, and then of course there's a self-selection process. So, those crazy people are the ones who apply and get into law school. You have to wonder about them to begin with. So you have that problem. Why else do lawyers have these problems?
Client base, largely primarily business oriented, where you're billable to your clients. So it creates a high stress environment and small business.
Yeah, that's exactly right. You have to please these darn clients. Lawyers will say life would be so much easier if they didn't have clients. The clients are, I don't want to overdo this, but they're a pain in the neck. And it's actually, I'm joking, but it is very stressful. Why else? Go ahead.
Lack of available supports maybe, or they're not aware of the supports that are available?
Yeah, that's true. More in the past, one of the things that is good in the United States, and I think may be true in Canada as well, is that there's an increasing recognition by bar associations that there are systemic problems for lawyers, and that there are problems, for example, to deal with alcoholism by lawyers, but some lawyers aren't aware of it, or some may not want to ask for help. Why else? Go ahead. That is exactly right. Hopefully, can everyone hear people's comments? I'm hoping what you just said was really important. You're thrusting yourself into conflict constantly, and that will wear you down. And particularly because you're doing this all the time. I mean, this is your job. So it's, I guess, a warning. Not to say, give up law school and go do something, a little healthier or happier, but just to be prepared for what you're getting yourself into. Some of the problems may be related to deadline pressures, heavy workload, financial pressures. Again, in the United States anyway, and I would bet it's true here in Canada as well. It's a business, and so you have to generate billable hours. You have to, meet your payroll. One of the things is that if you are in a private practice, there's something called overhead. And so you have all these people you're employed and employing, and you have maybe, and all these resources that you have to pay for. I don't know if you have the student loan debt that we have in the United States, but there's a lot of financial pressure, and so you can imagine how that would cause problems. There are interpersonal and political conflicts within a law firm and between lawyers on the opposite side. I remember when I was in practice one time, at the end of some hearing, the lawyer on the other side came up to me, and it was like he was just yelling in my face, this far from my face. It was like, in a sports game where a player is going up to the referee or the umpire and is just yelling at them. Well, that was what it was like. And it's conflict. It's not necessarily fun. There's a competitive nature of the adversary practice. You want to win. Shockingly, you want to win typically. One of the interesting things, again, often not talked about, but I think most practicing lawyers are aware of it on some level of consciousness, is an ambivalence about the obligation of loyalty to clients regardless of the effects on others. So if you have a client, you're representing a client, and they want to do something that you think isn't good for the other side, well, your job is to represent your client, and their instructions, at least in, and I assume that the ethical duties are pretty similar here in Canada as in the United States, and they may be wanting to do something that you feel is really wrong or bad, and so that can create a real dilemma. And in your your professional responsibility course or whatever you call it, I imagine you may be talking about what to do in that situation, but that's a challenge that probably comes up more often than you might imagine. Okay, so that's lawyers. Law students, this is a piece of cake, right? You don't have to do anything. You just come to class and hopefully keep your head down and the professor won't call on you. But other than that, it's, what could be easier? So, but there are risks to law students. What are some of the risks to law students? I don't know that any of you could identify with what it would be like to be a law student, but try and role play. Imagine that you were a law student. What would be some of those risks that law students might have?
Personal life suffers.
Okay, right. One of the things that actually I don't know that we've talked about, but I think the rate of, don't quote me on this, but my impression is that the rate of divorce may be higher for lawyers and law students, that it really can take a toll on personal relationships. What else? Nothing. All right, I'll tell you. The problems that I talked about with lawyers, well, some research says, guess what? It starts right here in law school. Some research says, you come in and you're fairly normal, and then by the time you leave, we've messed you up. And this is not quoting verbatim, but that's what some research suggests, that that you compare the population of law students when they start, and they're pretty comparable to the normal, the general population, and then by the time they graduate, they have a lot of the same problems that we find in practicing lawyers. And so the problems that And so it's not surprising. So symptoms may include, and see if you recognize any of these symptoms in yourself or others, your classmates. Obsessive compulsive behavior, oversensitivity, depression, fear, anxiety. I'm not going to stop. Hostility, social alienation. You recognize anybody? So, I mean, there are a lot of things. It's not a, I mean, it's not that law school is all terrible. You meet some friends for life. You get a chance to get free pizza. You know, it's not all bad, but it's competitive. It's stressful, and law students really do struggle. So, why do you think that law students have these problems? Do you think?
I think there's an amplification of the negativity bias that we're all predisposed of, plus stress and competition.
Yeah, all of those. Any other reasons? Go ahead. So it's typical of other educational experiences? Okay. So even international law students or international relations students might have some of these problems too. Although I don't know, but my guess is it may be a little more in law school. So some of the research talks about a variety of causes, so you can, as I go along, see if any of these ring a bell for you. Schools' overemphasis on scholarship and underemphasis on teaching, which you may not be tuned into yet. Overemphasis on abstract theory and underemphasis on practical training. Poor teaching and testing methods. I've written a lot about how the way legal education has room for improvement. Let me put it that way. Training students to ignore their values and make arguments they don't believe. Pay attention to that. This is something that you are going to be in a position where you're going to be asked to do these things. And in some ways, we're training you. I mean, they're training you. I'm retired, but they're training you to do this. You know, that's what this Socratic method is. You know, it doesn't matter what side of the argument you're on. You can argue either side, and it almost doesn't matter. And you know, when you're in law school, you're just talking about some abstract old case, not real clients who are, you know, living anymore where this case is pending. Doesn't really matter. In real life, it does matter. So there are these dilemmas that they have. Oh, more causes. The novelty of the subject matter, ambiguity of the law. A lot of people come to law school thinking, oh, you know, there's a legal problem, there's an answer. You know, there's a clear answer for every legal problem. But that is not the case. The law itself is often ambiguous. What will happen if you go to court is uncertain. Even if the law itself is theoretically clear, you have no idea who the judge may be or what the evidence will be or how the witnesses will testify. I'm seeing some lawyers nod your head, so you're just not sure. Heavy workload for law students. Of course, you guys don't really do work, you're just partying all the time, but for some law students, competition. One of the things that's just horrible from a pedagogical point of view is no feedback in many courses until the end of the semester, so you have no idea how you're doing, which, you know, in terms of educational experts, this is just really not the way you're supposed to be teaching people and having them learn. They should be getting regular, what's called formative evaluations, so that you know how you're doing and you can improve. But if you wait till the end of the semester and you get an exam and maybe you just get a number, and if you're lucky you go to your professor and they say, well, this or that, but this is not a good thing, and it causes a lot of anxiety. You're going along for a whole semester and you have no idea how you're doing, and you're going to go into an exam, you have no idea what the heck they're going to put on the exam, and maybe if they put a different question on, you do better. So a lot of anxiety. De-emphasis on personal relationships. There's this competitiveness, you're going to be working hard. It's a stressful thing, ignoring emotional reactions, and of course, you know, as was pointed out, you're probably not that emotionally healthy to begin with. So it's not, Reluctance to get help is another one, both for law students and lawyers. So, this is the important, this is the key thing. So what can you do? What can lawyers and law students to do to avoid and manage these problems? And I've been joking around up until now. This is a really serious thing and the upshot of this talk. And so, seriously, what can you do to avoid or manage these problems? Counseling, getting mental health services when you need them. What else? Quit? Well, for some people, I mean, you're maybe sort of taking on my smart aleck routine and making something of a joke, but for some people, this is not what you're cut out for. And that's something that's important to be self-aware about. And it's not for everyone. So, and one of the things, at least in the United States, and I'm guessing it's true here in Canada as well, is that there's this whole image in the popular culture about what it is to be a lawyer that is an unbelievable distortion. It's not what you see in TVs and TV programs and movies and in the news reports, which almost by definition are emphasizing the unusual. But people have these images in your mind. And so I think people come into law school having these hopes and expectations and these fantasies of Perry Mason, and Perry Mason, does that ring a bell here? Okay. But you have, Perry Mason was this, I'm dating myself, but it was this TV show long time ago, and it was so formulaic. At the end of the show, it was an hour-long drama, and Perry Mason was this great lawyer, and it was looking terrible for his client. And then, 5 minutes before the end, he has some witness on the witness stand, and through his expert cross-examination, he gets the witness to confess that he or she did whatever it was, and so he's the hero, and he brings his client, he saves his client's life because he's a criminal defense lawyer. But there's this kind of fantasy like that. Now, TV has gotten a little more sophisticated since then, but again, there's this image of lawyer as hero, and often it happens, but that's not the daily life in most cases for lawyers. And so anyway, this is a long way of saying, in terms of quitting, if you come in with unrealistic expectations, then maybe this isn't the thing for you. But there are other things you can do short of quitting. So what else can you do?
Professional associations.
Okay. Professional associations, working with colleagues, developing relationships. So, and for the law students here, developing good supportive relationships with your fellow students. One of the things I know when I was a law student, there was a lot of nice cooperation between students. There's a kind of image for a lot of law students that it's this competitive dog-eat-dog thing, that you want to get to be the top of your class and get the best grades, and so you can get the best jobs. And I imagine some of that goes on even for very nice Canadians. But working with colleagues in law school or in the bar is a really helpful thing, getting emotional support from colleagues. What else can you do?
Finally, to create a practice that feels like it has a sense of integrity. I'm a mediator. One of the things I appreciate most is that sense of collegiality.
That's a really important thing. Actually, when I got into mediation, that was a lot of the motivation for me, because I was much more comfortable in a role as a neutral than I was as an advocate. There are a lot of people who really can't imagine being a mediator, and being an advocate is really much more where they are at. But your general principle is exactly right. Part of it is a self-awareness. It's figuring out who you are and how this is going to fit into your life, and making sure that there's a kind of congruence between that. One of the things that I urged in my law school was to have students do very explicit, conscious, self-inventory, self-reflection about why you're here and what it is you want to accomplish and how you can make that happen. One of the things that happens, at least again in a lot of American law schools, and perhaps here as well, and not only in your law school but in others in Canada, is there's you just sort of sign up for the program, you take all the courses, and you just figure, okay, if I pass all these courses, then I'll do what I need to do and I'll figure it out when I get there. I would recommend that you do a lot of self-reflection and planning about what it is that you want to do in life and who you want to serve. What are the kind of clients that you want to work with? I did a lot of family law, which I found very satisfying. It was remarkably satisfying for me. I've talked to a lot of lawyers who say, I would quit if I had to practice family law. It's too darn emotional. These people are so irrational. Give me something like business where there's no emotion in business, right? Yeah. But the point is, figure out what is it really you want to do and have your work fit you. And that, I think, could help avoid some of the stress. What else can you do?
Sleep, drink water, eat good food, exercise, avoid drugs and alcohol, yoga, meditation, all that stuff.
Did you see my slide? I mean, I've got this. All right. So things you can do. Self-care. Pay attention to your reactions. Don't stuff them. So if you're having, if you're getting upset, if you're feeling stressed, don't just sort of cruise past it and ignore it and forget, say, well, I'll get over that. Pay attention to it. Don't use alcohol or drugs to solve your problems. I'm not someone who believes in complete abstention. Drink responsibly. I guess you can say use cannabis responsibly here. But don't use it to solve your problems. Here's the eat a healthy diet, get exercise, get enough sleep. One of the things that law students often do is pull all-nighters, particularly at the end of a semester. Pace yourself out, particularly for you 1Ls. Is that what you call you call them 1Ls here too? Really pay attention. This is hard stuff, and it's going to wear you down if you don't take good care. It's going to wear you down anyway, but it's going to wear you down a lot more if you don't do this good stuff. Maintain good relationships. If you are having problems, get help. Get help. And pay attention to your classmates and your colleagues and ask if they need help. And one of the things that I was talking with Heather, who can tell you at great length about the wellness program that you have here, which is incredibly impressive. Take advantage of it. You have incredible resources here. People really want to help. Heather can tell you, one of the things I noticed is you have on your walls about this wellness program and all the things that you can do. Take advantage of it. Don't just gut it through. Really do the things you need to do. In my law school last year, one student committed suicide. Doesn't happen all the time. Hopefully hasn't happened here or won't. It's an extreme situation. But I'm sure there are a lot of students who suffered in a lot of ways that obviously didn't lead them to kill themselves, but caused all sorts of problems for themselves and for their families. One of the things, I know in American airlines, air flights, you get on the plane and then the flight attendant goes through this routine, which mostly ignore, but maybe you've noticed that at one point they'll say, if we have a loss of oxygen, a mask will dangle down, put the mask on yourself first and then help somebody else. It's the same principle that if you aren't able to be competent for yourself, if you can't take care of yourself, you're going to have a really hard time taking care of your clients. You're not going to be a good partner to your romantic partners. You're going to not be a good friend. You're not going to be a good relative. So taking care of yourself is really important. This may be obvious, may be redundant. People have called me worse. But take it seriously. So one of the things that the book talks about is to help clients. So you've taken care of yourself. Hopefully you're in a situation where you've gotten integrity, you've figured out what you really want to do, and you're doing that. And you can help your clients as soon as possible by asking a number of questions, like, what are your most important goals? And don't assume it's necessarily to win or to get as much money as possible or to pay as little money as possible. Those may be some of their goals, but they often have other goals. So don't make those assumptions, because you know, if you make an assumption, you make an ass out of you and me. Ask what are some of your fears and concerns. You can say, what, you know, and don't necessarily say, ask them, do you have any fears or concerns? You can just say, what are they? And you can preface it by saying, well, almost everybody has some fears and concerns about litigation. What are yours? How do you think that litigation would affect your relationships and reputation? It can be stressful. How do you generally respond to stress? And then talk about a variety of different ways of handling disputes. So you can describe them, which you will learn about if you haven't already. What might be best for you? Which would you want to avoid? Why? So help them think through what process might be useful for them. And then you can ask bottom line questions. So how much would you pay, how much less would you accept or more would you pay to resolve a case sooner? I mean, a lot of people, and that's actually why settlements happen, is they'll say, gosh, this is too painful for me. I'm willing to take less. I'm willing to pay more, just get me out of it. It's unbelievable how palpable that is. I experience it a lot in the family cases I did, that there's just, I want to get this over. And it's also true in lots of other cases. How much less would you accept to avoid the risk of losing at trial, which is a huge thing. I mean, you could win, but you can lose. Would you prefer to have a trial, to present your case publicly and get a court decision, which we talked about as one of the benefits of litigation? Or would you prefer to settle to avoid the publicity and the risk of losing? For organizations, you can ask, how much time will the case require of officers, executives, and other employees? Something that I suspect that a lot of lawyers do not ask their clients. It's just sort of assumed that it happens and people will not think about it, but that's a huge cost for organizations, big and small. How would the case affect their goals and opportunities? How would it affect their potential for growth and innovation? How would the case affect and continued litigation affect the internal dynamics of their organization in terms of morale, absenteeism, and conflict, real consequences that sometimes happen as a result of litigation? How would it affect their brand and reputation? How much would it cost you to counteract the problems you've identified? How much would it be worth to you to avoid these problems? Or how much more would it be worth for you to pay to avoid these problems? So some more information. Again, you don't have to copy it. I'll post it on the website. Actually, the impetus for this talk was a blog post that I wrote called Legal Stress, which grew out of the work that I had done on the problems caused to law students and lawyers, as well as the research that Heather and Michaela did on research on the stress to clients. It also includes talk about, for those of you who are academics, the stress it causes on law faculty, which is also a grind. So it's a relatively short blog post. I wrote this article, Escaping from Lawyers' Prison of Fear. It starts off with this incredibly long list of things that lawyers are afraid of. It talks about how it analogizes what lawyers are doing to what members of the military face, because you're in conflict. I mean, it's not just solving a problem. You know, there's incoming. The other side is trying to thwart you. They're trying to mess with you. And there's just all sorts of things. So that's a useful one. I wrote this piece in my last lecture, More Unsolicited Advice for Future and Current Lawyers. It's more unsolicited advice because a former colleague of mine wrote one called my last lecture, Unsolicited Advice, and my first piece of advice is to read that article. It's a good piece. where this book that we're talking about that will be coming out in January. And then I have a lot of stuff on my website. So there's a lot more information that you can get if I haven't turned you off completely. So that's, well, actually, that's all that I wanted to present, but we have all of 4 minutes if you have questions or comments. Questions or comments? Where can I get more pizza? I have to go. Oh, we'll go. Go ahead.
In terms of that prison of fear that was mentioned, is regarding stigma and seeking help still out there, or is it just a fashion term?
Oh, I think that the question was, is there stigma for seeking help? And you better believe that there is. You know, one of the suggestions is going to a counselor. And that's a very touchy issue. So if you're a lawyer, just even suggesting that a client might consider going to counseling is a tricky thing, and you really need to handle that very sensitively because, you know, it's like, what are you telling me I'm crazy? There's something wrong with me? So you need to do that very carefully, like saying many people, I mean, one technique in general is to normalize it. Say, many people in this situation have this problem. I don't know if you do, or, you know, have you considered it? A lot of people are going to counseling already. Are you seeing a counselor? So short answer is yes, stigma is a real significant issue for clients and maybe for law students as well. Other questions or comments? I'm sorry I talked so long. I'm a law professor. What can I say? Go ahead.
Okay, so what about the confidentiality between the lawyer and the client, and the lawyer trying to go seek counseling? Maybe they're a criminal lawyer and seeing something that they can't disclose it to anybody, and then that kind of makes them, you know, turn into something else.
That's a good question. The question is about confidentiality. If you're a lawyer and you want to talk with presumably, hopefully a mental health professional, I assume, I do not know for sure, that if you talk to a mental health professional about a case of yours, that wouldn't be a violation, but I don't know. Do you know?
I know.
Oh, good.
There's a lawyer's assistance program, and so when you talk to them, they don't even take notes. Like, and you can tell them anything. You can tell them about your cases, about your crazy clients, about whatever. But going to the lawyer's assistance program, the counselors there have designed themselves so that lawyers don't have to be worried about that breach of confidentiality. In fact, like at all, because there's no notes, no nothing, because as lawyers, right, we're all paranoid about that. But no, it's like a steel box.
Yeah, one other piece of that, it's a great question, is, and one of the things that lawyers learn to do is to be able to convey things without disclosing names or other identifying information. So you can talk about a case, obviously without telling the client's name or details that aren't necessary for the mental health professional to know in order to be able to give you help. So I would think that would work. Is there time for one more? Well, that's okay. There's no time and you don't have any more, so.
Well, even if there isn't time for one more, I'm sure that John, and as people are grabbing pizza on the way out again, you'd be happy to talk to people a little bit one-on-one.
Absolutely.
So I just want to, on behalf of the College of Law at the University of Saskatchewan, thank John for being here. His words of wisdom are great, and I think what's really helpful is talking about these issues, making them public and transparent, and so that people can take steps to ensure that as law students and as practitioners that we are taking care of ourselves and then able to take care of our clients as well. So thank you, John.